Yes? Agreed? It's agreed. Accordingly, the House will now proceed to the consideration of private members' business as listed on today's order paper. Orders of the day, ordre du jour.
Members' business, consideration at second reading of Bill C-266, Respecting Families of Murdered and Brutalized Persons Act, standing in the name of Mr. Bazan.
Mr. Bazan, seconded by Mr. Cooper, moves that Bill 266, an act to amend the Criminal Code, increasing parole ineligibility, be now read a second time and referred to the Standing Committee on Justice and Human Rights. Debate. The Honourable Member for Selkirk, Interlake, Eastman.
Thank you, Madam Speaker, and it is indeed a pleasure for me to be able to rise to speak to my Bill C-266, the Respecting Families of Murdered and Brutalized Persons Act. And this bill will amend Section 745 of the Criminal Code. Now, this bill has been before the House before, and to quote one of my speeches previously in the House, I said back in 2014, in this bill, I want to empower our courts with the ability to increase parole and eligibility when sentencing individuals who have abducted, sexually assaulted, and killed our innocent and most vulnerable from the current 25 years up to a maximum of 40 years. Now, this bill isn't about creating stiffer penalties for sadistic murderers. These depraved convicts don't qualify for parole. My bill is about saving the families of the victims from having to go through the agony of attending unnecessary and traumatic parole hearings. So let's be perfectly clear, Madam Speaker. Bill C-266 is not about mandatory minimum sentencing. This bill is in compliance with Section 12 of the Charter of Rights. Now, based on, and the way it is that this is based on the discretion of the presiding judge through a recommendation to the jury. A judge can set parole ineligibility of anywhere between 25 and 40 years. It's not prescribed where they fall in there. They have the discretionary power of being anywhere from 25 years of parole ineligibility to 40 years. Now, this was modeled after a previous bill brought forward in previous Parliament, Bill C-48, Protecting Canadians by Ending Sentence Discounts for Multiple Murders Act, which we are seeing in use today with the MacArthur trial, as well as the murder that did the mosque massacre in Quebec. Now, that piece of legislation affords judges the opportunity to make the parole and eligibility periods for multiple murders consecutive rather than concurrent. And most of those convicted of these multiple murders or these heinous crimes of abducting, sexually assaulting, and murdering our loved ones never get parole. So why do we continue to put families through these unnecessary parole board hearings? There is absolutely no need to re-victimize those families. Now, as I mentioned, Madam Speaker, I brought this forward in previous Parliament. It was introduced back in February 27, 2013 as Bill 478. I made it as far as report stage, or up to committee stage, I should say, when I was appointed as parliamentary secretary, so I had to withdraw the bill. And then Colin Mays, our former colleague from BC, then picked it up as Bill C-587, and it made it through committee and came back to the House's report stage and third reading on June 2nd, 2015, but of course, I never made it to that final vote before the House recessed and the election took place. Now, as I said, this amends Section 745 of the Criminal Code, and by increasing parole ineligibility from 25 years to 40 years, you actually save families from having to go through the process of attending unnecessary parole board hearings and making victim impact statements, which are traumatic to say the least and heart-wrenching for those families, by 8 times. You will eliminate 8 unnecessary parole board hearings that they would have to attend, because these sadistic murderers often apply for parole every 2 years starting at year 23 for the sole purpose of toying with the families, of re-victimizing them and reliving the gruesome killings that they have committed. Now, so it's going to change a number of different sections under Section 745. Now, it is based upon recommendation by the jury. We are expecting, in the bill, it says that a judge must ask the jury at time of sentencing. He has to say if they wish to make any recommendation with respect to the number of years that the accused must serve before the accused is eligible for release of parole. So when the jury is passing judgment, they can also recommend what the parole and eligibility can be. And the judge has discretion on whether he accepts that or not, and he may or she may, on their own accord, set it at a level that they find appropriate. Because all judges on the board, when determining parole and eligibility, must have regard to the character of the offender, the nature of the offenses, and the circumstances surrounding their commission. Now, over the years, I've had the pleasure of working with a number of people on this legislation, along with Colin Mays, the former member of Parliament from BC. So over in the other place, Senator Boisvano was a big help on this back over the years. He founded an organization called Murdered or Missing Persons Families Association. This is something that he's incredibly passionate about. Sharon Rosenfeld, her son Darren, was murdered by Clifford Olson, the notorious Clifford Olson, and her organization, Victims of Violence. Susan Ashley, the sister to Linda Bright, whose sister was killed by Donald Armstrong. Terry Praiello, her sister Darlene, also called Dolly, was murdered by David James Dobson. And also the organization Canadian Parents of Murdered Children has provided input over the years. And this goes back some time. I got interested in doing something for families back at the end of 2009, 2010. If you remember the terrible abduction, rape, and murder of Tori Stafford. And Terry Lynn McClintock, of course, got arrested and prosecuted in 2010, and Michael Rafferty in 2012. And during that time, while my heart was breaking listening to the Tori Stafford story, Clifford Olson was dying in prison from cancer, and Sharon Rosenfeld was on the radio talking about how this killer had impacted their family over the years, where he would send letters to them describing how he murdered their son, Darren. And because of that type of sadistic behavior of tormenting these families and using parole board hearings to feed their own sick appetite, it became apparent to me that we needed to do something for families. And I knew full well that both the murderers of Tori Stafford, that Michael Rafferty and Terry Lynn McClintock will be applying for parole board hearings at year 25, or year 23 after that murder of 2009. And so that, I think for all Canadians, would be considered unacceptable, that families would have to go through this ongoing saga of parole board hearing after parole board hearing after parole board hearing. Now, we need to make sure that this is legislation, Madam Speaker, that is targeted at the most depraved of our society, the sadistic murderers who go out there and often prey on children and those that are the most vulnerable, that they abduct these individuals, that they sexually assault them on numerous occasions, and then finally murder them, and often in very gruesome manner. So we're talking about people like Robert Pickton, Russell Williams, Michael Rafferty, as I already said, Clifford Olson, Paul Bernardo, David James Dobson, Donald Armstrong, Luca Magnotta, and we're watching the MacArthur case unfold right now in Toronto. And so this would apply to those individuals, especially those in particular that aren't going to be getting consecutive life sentences, that they would be eligible up to, or they could have a 40-year sentence applied upon them before they can apply for parole and eligibility. I think it's important that we talk about some of these families, like Linda Bright, who was just 16 when she was abducted by Donald Armstrong in Kingston back in 1978. And he has applied for parole board hearings numerous times over that time frame. And I can tell you, I've been talking to Susan Ashley, Linda's sister, and she has said about the parole board hearings in the past, she says, "My heart breaks having to live through this again. My heart breaks having to watch my mom and dad drag up their thoughts and pain from that deep place inside them where they tuck away their hurt. Now, Linda's mother, Margaret, has said as well when she did her victim's impact statement, this is not fair. We should not have to relive our tragedy. When I remember my daughter, let me remember her as a little girl. Don't make me think about that other awful time in 1978. Let me tell you, this has been the most difficult thing I've had to do in the last 20 years. Gary Rosenfeld, who was Darren Johnson Rood's father, he was married to, or he's now passed away, but his wife is Sharon Rosenfeld. And he said, after going through a number of parole board hearings in 2006, 2010, and even back in 1997 when there was still the faint hope clause, and he said publicly, what's really horrendous about this is only the beginning. We're going to have to do this every 2 years as long as Olson lives. And this is a very, very painful experience for myself and my family. It should be noted that Clifford Olson died in prison, never got parole. These individuals don't get parole. And Darlene Prioriello, and she was abducted, raped, mutilated, and murdered by David James Dobson in 1982. He's at the Bath Institute, and Terry has said we're having to go through these painful experiences at these repetitive and unnecessary parole board hearings. Says families have already been victimized once. They shouldn't have to be victimized every 2 years. Having to face a loved one's killer and to read what he did to her and how her death has affected our lives is something nobody should ever have to do once, never mind twice. And unfortunately, that goes on. Now, I can tell you that we've had the Library of Parliament research how these murderers have been treated in prison and whether or not they've ever received parole. And the best that we can find is that some of them have been given day parole or temporary leave, but never, ever released back into the public on full parole. They are serving life sentences, and they will continue to do that. So a lot of people wonder how I came up with the 15 extra years, 25 plus 15, while murder is 25 years without parole. Abduction is a maximum of 10 years without parole, and sexual assault is a maximum of 4.6 years without parole. Add them together and you get 40 years. So let's be clear that I'm not saying that we are setting mandatory minimums and taking it up to 40 years. It's anywhere in between that the judge and the jury decide where that parole and eligibility should be set, Madam Speaker. So it could be 25 years, it could be 30 years, it could be 35 years, it could be 40 years. It's up to judge and jury to make those decisions. And by respecting the independence of the court, we are in compliance with Chapter 12 of the Charter. And we've seen this type of approach being taken in previous legislation, and this judicial discretion is incredibly important because the judge will take that recommendation along with the regard that he has to have for the character of the offender, the nature of the offenses, and the circumstances surrounding their commission. And if the jury chooses, they can provide input as well. So as we wrap up the discussion, and I'm looking forward to hearing the position of the government on this. I'm looking forward to seeing what the NDP are, but I am appealing to all members of the House to support this. And it should be noted that in the previous Parliament, that all Liberals voted yes at second reading for this legislation. And many of them sit on the benches today that are still here. And I want to make sure people understand that these depraved murders, these brutal and sadistic members of society are never released back into society. And if they're not going to be released, and if the Parole Board of Canada continues to hold them in institutions, knowing that they are dangerous offenders and potentially could reoffend again because so often they are psychopaths, Madam Speaker, then let's ensure that we aren't re-victimizing those families by having to go to all these unnecessary parole board hearings, having to relive the murder and the brutal details of how their loved ones were killed, all to the self-gratification of those incarcerated psychopaths. Madam Speaker, I ask that everyone support us, support this legislation. Let's get it to committee. Let's hear from the victims' organizations, the families that have been impacted, and the families that are calling upon this. Let's give them some peace. Let's respect their wishes and respect their lives so they do not have to go on and on living this nightmare. As Yvonne Harvey of Canadian Parents of Murdered Children said, although I've not personally faced the ordeal of a parole hearing, I have spoken to many individuals who have. I'm certain that the primary intent of this bill, to spare the families of victims from having to attend unnecessary parole hearings, would be most welcome. Thank you, Madam Speaker.
Questions and comments? Questions et commentaires? The honourable member for Victoria.
I appreciate the work of my friend from Selkirk Interlake Eastman for bringing forward this initiative. He indicated in his remarks that he did not think that this bill transgressed the Charter of Rights and Freedoms, the point about presumed cruel and unusual punishment. He said that because he claims there's this discretion available to judges on sentencing or juries between 25 and 40 years in his scheme. My question is, does he have a formal legal opinion to that effect, or is that simply his idea?
Honourable member for Selkirk Interlake Eastman.
Madam Speaker, I can tell the member that in the previous Parliament, I discussed this with the Department of Justice, along with the judicial team at the Library of Parliament, to ensure that this was in compliance. It is falls along the same suit of Bill C-48 from that Parliament, which is still in use today and is in compliance with the Charter. So this isn't about anything that is considered cruel and unusual punishment. Madam Speaker, this is a piece of legislation that provides full flexibility and independence to the courts to make these decisions.
Questions and comments? The honourable member for Kingston and the Islands.
Thank you very much, Madam Speaker. And thank you very much, Madam Speaker. And despite the fact that this might be in compliance, as the member is suggesting, I'm just curious if he can explain the process last time of it coming through the House, being voted on. And I understand that it sat on the order paper for a while, and for some reasons it didn't move forward from there. But why didn't the previous government pick up on this? Is there any insight into why it wasn't moved along by the former Conservative government?
Honourable member for Selkirk Interlake Eastman.
Well, I can tell you, Madam Speaker, if I can pull it up here, this piece of legislation I tabled in February 2013. It was given second reading June 5th, 2013, because that's where I came up in the draw, Madam Speaker. It was reinstated after the recess. It was already through second reading and referred to committee. I was then appointed as parliamentary secretary. As parliamentary secretary, not allowed to carry any private member's business. So it was picked up by my colleague Colin Mays, who then brought it back in April 2014. It was then given second reading through that time and referred to committee after the summer break, September 24th. It came through committee, and if I recall, committee, Madam Speaker, was jammed up with a number of different pieces of legislation, but it was reported back on April the 1st, 2015, and report stage here June 2nd and third reading at the same time. So it came through the normal process as private members' bills do, and as the member fully knows, that's often we are down lower in priority, with only given an hour a day in the House to have these types of debates and discussions, and government business takes precedent at committee over private members' bill. I'm hoping that we can get everyone on side and move this through quicker, knowing the time frame that we have in front of us and recessing at the end of June.
The honourable member for St. Albert, Edmonton.
Thank you, Madam Speaker. I want to thank the member for Selkirk Interlake Eastman for his leadership in bringing forward this bill. The fact is that murder is the most serious offense in the criminal code, but not all murders are equal. Some are so heinous, so sadistic, so violent that they're really in a special category. And as the member pointed out, that is the object of this bill. And I agree wholeheartedly with the member that it is important that we pass this bill at second reading to get it to committee, so to hear, as he said, from some of the victims' families and friends. But as the member pointed out, in the last Parliament, it was studied at committee. I was not there in the last Parliament, but I did read the transcripts from